Let's get down to business, talking about real estate, and joining us to talk about real estate from TalkRealEstateAZ.com. It's Laura Bramnick. Hi, Laura.
Hi, Sinclair.
Good to see you again.
It's great to be here.
Laura Bramnick is an attorney. She is also a real estate agent. She's also a consumer advocate. And I think that's one of the most important things that people can think about when it comes to a real estate transaction. You need somebody on your side.
You definitely do. You know, there's just so many issues that come up that even if you're not dealing with somebody who has bad intentions, can hurt you in the transaction.
That's right. Because
you're just not aware of them. Where somebody like me, I can't say I've seen it all, but I see a lot, you know.
And you're an attorney as well as a real estate agent. A lot of people just work with a real estate agent, and Arizona is kind of unique in that regard. Many other states require a real estate agent to be a real estate attorney as well.
Yeah, they don't permit the agents to draft the contracts and negotiate, because that is considered practicing law. And it technically is even here in Arizona,
yeah.
But we have a constitutional amendment that permits realtors the limited ability under our law to draft contracts, draft and negotiate contracts.
It's a lot more complicated than that sounds. I mean, you say draft a real estate contract, and I know Arizona has a standard kind of a boilerplate real estate contract, and it's a good contract.
I think it's excellent, but that's where you start, not where you end.
Right.
I think that's the real issue, because it's not a one-size-fits-all transaction.
Well, you've said to me in the past, all real estate is unique. So it would just make sense that a real estate contract might have some unique features as well.
Yeah, everybody has different needs and wants, and you know, you have to understand what contingencies are appropriate, and you don't have to use the timelines in the contract. You can extend them or reduce them, and you want to make sure that you really know what your client's needs are. You have to have more than just a short conversation about, I love this house, I want to buy it.
There's negotiation that is involved, and it's not just for the price, it may be for the terms of the contract as well.
Absolutely true. You know, sometimes a buyer is willing to pay a higher price in exchange for a longer escrow period or some other issues that may be involved.
Or maybe they just want a longer escrow period and they don't want to pay more.
No, that's true. And for me, one of the biggest issues in the contract is the inspection period. I just find the boilerplate says 10 days, and I just find that 10 days is not enough. And the biggest issue that sellers run into is if you have a lot of offers, or if you have a lot of offers, or if you have no offers,
Mm-hmm.
you know, because it's a case of supply and demand. You know, remember when the bubble hit,
Sure.
before it burst, you could have people without even seeing property putting in offers that were list or over. And as a buyer, you couldn't really compete with that if you wanted to do inspections or, you know, more thorough inspections,
Right.
or if you wanted to add contingencies to the contract. But again, that's part of the bargain. That's part of, okay, you sit down with your realtor or your lawyer or both and say, this is the reality. Let's make a list of what is negotiable and what is non-negotiable.
And as you've told me in the past, everything is negotiable.
Everything is negotiable. And so you have to decide, is this really, how important is getting this house to me or selling this house to
Right.
me? You know, am I willing to give up potentially some of my rights?
What compromises and concessions am I willing to make, and which ones do I want the other party to make?
Yes, correct.
Okay. Let's run through some of the real estate contracting, cover some of the essentials that everybody must know about the real estate contract. And I would say the first thing that probably a lot of people don't do, read it.
Yes, read every word. I know it can be tedious. at the very least, insist your agent sit down with you and go through it paragraph by paragraph. When I represent a buyer or a seller, that's what I do. I say, please allow me 45 minutes to an hour. I want to go over it with you. Because there are things, every time I do it that way, there are things my client will tell me they weren't aware of.
Bless your heart, Laura, because there are so many real estate agents in this state who would just say, here's the contract, sign here, initial here, sign here, initial here, flipping through pages as they go.
Well, to be honest with you, it's worse than that, Sinclair, because they do it by email and DocuSign.
Oh, yeah.
So they say, sign, here it is, print it and sign it. Or you don't even have to print it anymore, because you can sign,
Yeah.
digitally on the computer. And the DocuSign in and of itself is totally fine. It's just that you need to understand each and every part of the contract. And if you come back later, after you've signed it, and say, I didn't understand, except in rare circumstances, the courts will not protect you.
Oh, you've told me this as well. If you sign, you bind.
Yes, if you sign, you bind. There's a reason under the statute of frauds that real estate contracts have to be in writing.
Right.
And the reason is that real estate is unique, and it is most of the time more expensive than a normal contract, and so it has to be in writing. It's very unusual if you've made an oral agreement that the courts will uphold that. We never say never in the law. Most lawyers are known for saying, well, it depends, but I'm letting you know that it's rare and you don't want to count on that. So the contract is binding once you sign it, and that doesn't matter if you have buyer's remorse or seller's remorse. If you end up having buyer's or seller's remorse, there may be another part of the contract that you can cancel, but you have to have a legal reason to cancel the contract, or you have to get the other party's consent.
Well, and that's a good point. If you think something might happen, if it's a consideration that you feel is important for you to include in the contract, you could include something that could give you an out.
One example, one red flag that I see over and over again is if somebody is elderly, they've lived in the house for a very long time, and they may be moving in with their children, or they may be going into assisted living. I find that segment of my clients have the most seller's remorse. So if I represent a client like that, many times I will put a contingency in there, or I will have a longer close of escrow, or something that in some way can protect them, where the assisted living is, where they actually have to have that contract with assisted living accepted, those types of things.
Right.
Because
so you can include contingencies.
Yes, and they have to be worded properly, obviously, and you may not get every buyer to agree to that, but the most important thing is that you want to find out from your client, what if you change your mind? You've made this decision quickly, let's say, to move in with your kids.
Right.
Maybe you've fallen and broken your hip or whatever.
But that brings up also some other ideas about contingencies. Some people are going from selling one property and buying another.
Right.
It can be contingent upon financing. It can be contingent upon any number of different things.
Well, contingency upon financing is very well accepted. There's very few contracts, unless it's specifically stated in the contract, that you can't cancel if you don't get financing.
Okay.
You've raised a real problem in that certain contingencies are accepted by tradition and certain contingencies are not. And you shouldn't really be limited by what other people do.
Right.
There's certain contingencies that apply to you, and the financing is a biggie. And I understand that you're reliant on a third party, so I understand why there's a financing contingency, and many times there's an appraisal contingency. So you want to say, okay, what contingencies apply to me? Certainly if I'm selling a house. But there's other things that can come up, and so it's really important to interview your client thoroughly.
You mentioned that all property is unique, so that requires then specific performance in the contract, correct?
It's interesting because I can't tell you how many clients will say to me, the court would never force me to sell my home. You know, even if there's damages, they can't force me. But yes, the law is very clear that real estate is unique, and if your seller cancels the contract with no legal reason to do so, you can go to court and the judge can force that seller to deed you the property.
Doesn't happen too often, I
No,
imagine.
but it does happen. It
Yeah.
definitely happens. And it happens when you have seller's remorse. Maybe something's happened like, the most common scenario that I see is like, and maybe I represent somebody who's a divorced or a widow, and they're getting married again, and they're selling their house to move in with their new spouse.
Right.
And all of a sudden, they break up. Now, that person doesn't want to move because they have nowhere to move to, you know, those types of things.
But they could be looking at damages at the very least
Yes. And-
payable to the buyer.
Yes,
Yeah.
and so you can definitely put that contingency in there. So real estate is unique, and the buyer can sue for specific performance. And the seller could technically sue for specific performance, but you would have to prove that the buyer has the ability to pay.
Okay. Meanwhile, getting into and through escrow can be a challenge for anybody almost any time. You've got inspections, appraisals, financing, all these things. You got to work with the title company, and boom, that date is upon you within 30 or 45 or 60 days or whatever it is, and you're calling everybody, and if one person isn't ready, it can make a big mess of things. But escrow is a very specific date written into the contract.
Yes, and if you go beyond that date, you have to get all parties to sign the extension. So if close of escrow comes and the buyer or seller isn't ready, for whatever reason, they're in breach. There is an exception to that, and that is that the boilerplate of the Arizona contract, the Association of Realtors contract, has a paragraph called a cure period. So it allows each side 3 days. But in addition to that, it's not an automatic 3 days. You actually have to notify the other party that they have 3 days.
Yeah.
Now, I'm a proponent of deleting that. I don't like the cure period. Unless my client needs it for some reason and the other party doesn't care.
So you kind of like to put the other party's feet to the fire, is what you're saying?
You know, if you need more time for close of escrow, then let's put it in the close of escrow date. Because the cure period is, like I said, you actually have to give written notice, and then the 3 days starts. So it's not, if you don't close on that date, it's not an automatic breach. And I just, you know, other contracts are binding. I'm not used to a contract having this limited floating date kind of thing. And the biggest issue we see is
really,
lenders.
Even though there's a cure period, it's really not a floating date at all.
It really is not. And the biggest issue that I see is that the lender's documents are not at title.
Yeah.
And so you've got to take this transaction very seriously, and you have to be on top of it at all times.
Which means that those documents need to be in place by the time you're starting to sign the contract, not close the escrow.
Well, the contract says the documents have to be there 3 days before.
Yeah.
So, and now you have new federal guidelines called TRID, and they take more time to, and it's really for the purpose of protecting the consumer, but many 30-day closings, which were traditionally 30-day closings, are now 45, meaning that people say
It has
45
changed.
days. Yeah, it has changed a lot.
All right. Laura, stick around. We have more to talk about. We're taking a look at real estate contracts today with Laura Bramnick from TalkRealEstateAZ.com. Laura is a real estate agent and also a real estate attorney. Great combination. 480-624-2705, 480-624-2705. and the website, talkrealestateaz.com. More in just a moment.
Okay.
Okay. Money Radio, we're back with Laura Bramnick from talkrealestateaz.com. Laura is our pro when it comes to real estate in Arizona. She's a real estate agent. She is a real estate attorney. You're licensed to the State Bar of Arizona. You specialize in real estate. You've been doing this for quite some time, a lot of experience. You've seen a lot of things that go into a real estate contract, much more than just a regular real estate agent. You know the law behind it as well.
Correct.
And that's important. There are a lot of little things that we can't forget. In fact, there's a whole area where they add on little things to the real estate contract, addendums to the contract.
Yes, that's true. There are lots of addendums, and they deal with whether you have a well, whether you have septic. HOA is a big one, because you want to make sure that it now has gone from a 1-page to a 3-page addendum. And that's because the real estate department wants you to disclose more about the HOA. And many of us, myself included, have 2 HOAs. We have our own development, and then our development's in a bigger development, which is another HOA.
Okay.
And so it can, it can be a lot to take in. And you want to know what the dues are, if there's any assessments, if there's any HOA liens. There's so many issues. You may want to know what the board of directors, what their makeup is, and the biggest suggestion that I can make for buyers is to read the CC&Rs. I can't tell you, they're not all the same. I know they're long and tedious, but you got to know some of the key issues, because many times people will get a violation after they've moved in and have no idea that they weren't allowed to do that.
Right.
So it's a big deal.
Another big area when it comes to the contract is the disclosures.
The disclosures are huge. Now, Arizona law is very clear that sellers have to disclose material facts. But there can be a disagreement on what's a material fact.
Okay.
And also, I can't tell you how many times sellers say, I didn't know. I didn't know I had termites. I
Yeah.
didn't know there was mold behind the wall.
Right.
And sometimes they didn't.
Mm-hmm.
But then, was there water dripping from the ceiling and they ignored it, which is one scenario? Or was it truly hidden where, unless they had some reason to, let's say, open up the wall,
Right.
they truly didn't know.
Yeah.
So,
But if you've got water dripping down a
Yes.
wall, you need to understand there's a good probability that there could be mold that comes about from that.
there's a roof leak and mold.
Yeah.
So it's really important to get the property inspected, and you may also want more sophisticated inspections by specialists with air conditioning, roof, plumbing, electric, because you can move in and have major problems with a house, and it can cost a lot of money. And many times you can't finance those repairs like you can the purchase of the house.
And then there's some more unusual disclosures, like if somebody dies in the property, do you have to disclose that?
You do not. No, you do not have to disclose
What if
somebody
somebody's
died.
murdered in the property?
You do not have to disclose that either. Now, you can look at the public record. Even the sex offender, you don't have to disclose that. So there's issues that if somebody who died had HIV or AIDS, you don't have to disclose, communicable disease, you don't have to disclose that. And so you as a buyer may want to research that on your own. I know sex offenders, there's a registry. You can contact the police department,
Yeah.
although the different levels. So I think the lowest level doesn't have to be disclosed.
You've got a walkthrough, that's part of the process as well.
Yeah, and also take the SPUDS seriously. That stands for Seller's Property Disclosure Statement.
Uh-huh.
I can't tell you how many disclosure statements I review and there are blanks, because it's like 7 pages of check marks. And I go through them line by line, and some of those are blank. And so you don't know if the seller overlooked them or if the seller is trying to avoid telling you something. And so you've got to be careful about that.
Can the seller just say, I don't know?
The seller can definitely say, I don't know, and that's valid. That means you as a buyer need to find out for yourself.
Okay.
If the seller does know and they say, I don't know, that's a breach of the contract.
Right.
Okay. And also read the appraisal. The appraisal can have some valuable information as well.
Okay.
And so that's also very, very important.
Now, what about the walkthrough period? Is that actually part of the contract as well?
Yeah, the contract, the boilerplate that it actually states that the buyer has the ability to have a final walkthrough. And if the buyer does not have, if they choose not to do it, then they can't make a claim against the seller for breach of contract on something that could have been discovered at the final walkthrough. So the main purpose of the final walkthrough is to make sure that everything is in the same condition that it was when you purchased the property, when you made the contract. So let's say if there was, let's say the washer and dryer are missing,
Right.
and the washer and dryer are part of the contract, that's obvious. But there can be other things that were taken out that that you may not be as aware of as quickly, you know. So you want to know that.
And I think one of the things that we always need to remember is that if it's a verbal representation, it's worth the paper it's written on.
Yeah, do never, ever, ever, ever rely on a verbal representation. And when somebody tells you, whether it's a realtor or the other party, don't worry about it. You can count on my word. That is not true.
You can count on the contract.
You can count on the contract. You want it in writing. I know sometimes it's a hassle to stop everything and getting in writing, but you'll be so happy that you did, because if you have to pursue the other party afterwards through someone like me, it is expensive, it is time consuming, and it is stressful.
Well, starting with someone like you though, as a real estate agent, you can provide your legal services, and sometimes that doesn't cost anything extra.
Yeah, it depends on the situation. Because I have my real estate license, if I can find a way to get paid through the transaction rather than as a separate legal fee, I will do that to help my client.
But if something goes wrong, you weren't involved, and they come to see you later, then you're just working as a real estate attorney, and you receive hourly fees for that.
Yes, and it can get, if there's a lawsuit involved, it can get expensive. And many times, if it has to do with repairs that weren't disclosed,
Yeah.
now we need to get experts. You know, it's not just my fees, but it's fees of general contractors and licensed professionals.
So we talk about this old idea of an ounce of prevention is worth a pound of cure. It really does apply to this entire process of the real estate contract.
You know, you should really budget. You shouldn't buy a house at the top of what you get approved for. You should get a little cushion to get inspections and lawyers and whatever else you need to make sure that you are happy with your purchase.
Talk to Laura Bramnick, 480-624-2705, 480-624-2705, talkrealestateaz.com, talkrealestateaz.com. Laura, I've really enjoyed the conversation today. Thank you so much.
Thanks, Sinclair.